Hey everybody, it's Steve Vladeck. It's Sunday, January 25th. Usually I use these videos to do updates on the Supreme Court and what it's up to, and I'll continue to do that. But I wanted to take a minute today to talk about the claims being made by the Trump administration that ICE agents have the authority to go door to door, including in Minneapolis and St. Paul, and enter into people's homes without a judicially signed warrant. We saw this perhaps most directly on Thursday when Jimmy Percival, who is the general counsel of the Department of Homeland Security, published an op-ed in the Wall Street Journal. And Percival's op-ed basically makes two claims. The first is that what he calls illegal aliens or undocumented immigrants don't have the same Fourth Amendment rights as other Americans or non-citizens. And his second claim is that when the non-citizen is subject to something called a final order of removal, they are effectively a, quote, fugitive from justice, unquote, and therefore their homes can be entered with something called an administrative warrant, which really is just a piece of paper signed by an ICE officer. Both of those claims are bunk. The Supreme Court has never actually held that the Fourth Amendment doesn't apply to undocumented immigrants. Indeed, the text of the Bill of Rights repeatedly refers to persons, not citizens. It doesn't distinguish based upon citizenship. It doesn't distinguish based upon immigration status. Indeed, the only thing the Supreme Court has ever said that comes close to what Mr. Percival claimed in his op-ed was in 1990 when the Supreme Court said the Fourth Amendment didn't apply to the search of a Mexican national's home. The only problem is that that was entirely because the Mexican national's home being searched was in Mexico, not Minnesota. So it might be true that the Fourth Amendment doesn't protect non-citizens outside the United States. There's no case law for the proposition that our neighbors, our friends, our fellow Americans have fewer Fourth Amendment rights based upon their immigration status. Turning to the second claim, this idea that once you have a final order of removal, you are a fugitive from justice if you're at liberty, that is utterly belied by the government's own behavior. Most immigrants, including those who are subject to orders of removal, are nevertheless allowed to remain at liberty until they receive something called a bag and baggage letter, telling them when they have to report to deport or when they have to deport by. Indeed, the government routinely conducts removal hearings in absentia, meaning without the individual even present. And so you can't actually be a fugitive from something you don't know is happening. Really, the better way to think about folks who are under final orders of removal is the same as criminal suspects and defendants who have been released on bail. They are allowed to be free. They do not have far diminished constitutional rights just because the government is in the middle of pursuing legal process against them. This doesn't solve all of the questions about what ICE is doing with its door-to-door searches in Minneapolis, St. Paul, and elsewhere, but it does suggest that the chief lawyer for the entire Department of Homeland Security either doesn't know what he's talking about, or even worse, he does, and he's writing op-eds in the Wall Street Journal that say things that are utterly false. Either way, I hope you now have a better handle on what's going on. I'm going to write more about this in my newsletter called One First, which you can find at stevevladeck.com for Monday. And I hope you guys are all staying safe out there in the interim. Thanks so much for watching. I'll see you next time.